Welcome everybody. Thanks so much for joining us on day 2 of these webinars. Today, we're going to be talking about employment law experts with employment law experts to navigate changes required by the new laws. This is part of Generator's emergency response program that we are doing in partnership with NMotion and the Lincoln Partnership for Economic Development. Thank you so much again for everyone joining. If you're having computer audio issues, know that you can call in. There should be call-in info right here. So just use that, dial that number. It'll ask you for the ID, dial in right there, just in case your audio from your Wi-Fi isn't working. And then, for questions during today's webinar, one, you feel free to send me any emails to danny@generator.com with any questions, and we'll get back to you as quickly as possible. But know that right below you, there is a Q&A box. Feel free to just type in the questions, send to the host. We should have time at the end to go through each question and answer it. Any unanswered questions, though, don't worry. We're going to send them to the speaker to answer after the webinar. Don't send your questions anonymously so we can ensure we can get your answers back to you appropriately. But again, if anything, feel free to just email me and I will take care of it. So again, unfortunately, due to the number of people on today's webinar, we'll be unable to solve any technology issues. But the silver lining and the good news is that we are recording this webinar, and we will share it with all registered emergency program participants, as well as put it on our website at generator.com under resources in the emergency response program tab. But it's my pleasure to introduce our speaker, Margaret Schiefen. She's the principal attorney at Enterprise Legal Studios and just the person that we want to chat with this. So without further ado, I am going to make you, Maggie, the host, so then you can share your screen here. Oh, Maggie, I need you to start your camera.
Start my camera.
It should work.
Okay. Does that work? And now you want me to share my screen?
It should.
Yep, perfect. Yeah, you should be able to now.
Screen 2. Do you have some slides?
Not yet.
It says I am sharing screen 2.
Try to. Interesting.
I'm going to stop the video.
Yes.
That's what I did last time. I stopped the video and it worked a little bit better. Bear with us, everyone. Do you have screens?
Working towards.
Not yet. So yeah, so you're going to want to go to that green button right there, click share screen, and then select which desktop, and then click the share button on the bottom right. There you go. Now we're seeing it.
Beautiful.
Awesome, and that's all the time we have for today. Well, good afternoon, everyone. Thank you so much to Generator, and specifically here to Danny and Gisela. We are going to talk about some of the new laws and the new requirements for employers, specifically under the Families First Coronavirus Response Act. But we're also going to get into some other areas. Some of them we're just going to briefly touch on. So certainly, if you have questions, let's get them through the Q&A. I totally get that this is not the March Madness that any of us were hoping for, so let's do our best to navigate through these tough times, specifically as it relates to you as an employer. So when you look to some of these new laws and the amendments to some old laws, the FFCRA essentially has 2 requirements for leave: paid sick leave and paid FMLA leave. We're going to talk about those in pretty good detail. We're also going to talk about the relation to the other leave, some tax credits and deductions that employers do have, and some other employer implications under the CARES Act that you may or may not be interested in. So there's two buckets of leave under the FFCRA. The one bucket is emergency paid sick leave, which is a new law under the FFCRA. Then the second is an amendment to the FMLA, which gives emergency paid FMLA leave. Are you covered? Yep, probably are if you're on this webinar. It includes all private employers that have less than 500 employees. There's an asterisk there because there is some proposed legislation to cover over 500 also. And most public employers, regardless of how big or small they are. So who's not covered? Private employers with over 500 employees. There also are some excluded employees, which are healthcare providers or emergency responders. That typically applies only to employers who specifically employ those type of workers. Possible to have other application, but most generally those employers that actually employ those. There is, thanks to a last minute change, a small business exemption. Pretty tough, but there is a small business exemption if you have less than 50 employees. And the reason for the leave is only the child care provisions. So if daycare is closed or school is closed for a COVID-19 related reason, and you have less than 50 employees, and I'm going to say a lot of ands during this slide, and if providing that leave actually jeopardizes the ongoing nature of the business, if you as an employer determine that providing that leave results in expenses that exceed your revenues and would actually cause you as a small business to cease operating at a minimal capacity, if the employee's absence would entail a substantial risk to your finances and to your operations, because that employee who's requesting the leave has a special skill set and knowledge of the business that would actually be a risk to your business if you let them take the leave, or if there are only a few employees that actually have this skill set to perform this service and you couldn't operate at a minimum capacity. So if you have less than 50 employees and actually meet that criteria where your business is actually in jeopardy, if you provide that leave for childcare only, then you're exempt from the childcare provisions. You don't have to submit anything to the Department of Labor or any other governmental entity, but you'd need to document it pretty well. There are posting requirements. So right next to all of your other wage and hour posters and other required posters, you have to have a poster specific to the emergency paid sick leave and the emergency family medical leave. And I provided that site here on this slide. Layoffs. What if you end up laying off some employees? Are they going to get a substitution of some of this leave? Well, first of all, let's remember that the FFCRA, so these leave requirements aren't applicable to anything prior to April 1. Then if you close after April 1 or lay off an employee after April 1, but before that employee actually takes leave, then the requirements don't apply except for any period of time between April 1 and the time the employees are laid off or furloughed. So if you actually lay off an employee on April 10th, or if you close your business on April 10th, the only leave time that applies to those employees is between the 1st and the 10th. When can an employee, if you look at this first bucket, the new law, when can an employee take this 2 weeks of emergency paid sick leave? There are 6 reasons. First, if they're subject to a government quarantine, and these all have to be COVID-19 related reasons. If they've been told by a healthcare provider to self-quarantine, if they're experiencing symptoms of COVID-19, the cough, the temp, etc., and they're seeking a medical diagnosis, then they're entitled to this leave. If they're caring for someone else who either has been quarantined, told to self-quarantine, and getting a medical diagnosis, then they're entitled to this paid sick leave. If they're caring for a child whose childcare or school is closed because of COVID-19 reasons, then they're entitled to the leave. And then lastly, if they have any other substantially similar condition that's specified. What is this? It took me a while to figure out what this 6th one is. It's sort of an out for the government that if something else comes of this pandemic that's related, it will just be able to be thrown right in here. So what is the employee entitled to? Well, full-time employees are entitled to 2 weeks of emergency paid leave. So 80 hours, it's 80 hours over a 2-week period. Part-time employees are entitled to whatever amount of leave to their average number of hours over the course of a 2-week period during that same 80-hour period. So look back is 6 months, look to their average 2 weeks of work every 2 weeks, what's their average, and that's what they're entitled to during an 80-hour 2-week period. So this leave is available regardless of how long the employee has been with you. So if they started March 15th of this year, they're still entitled to this leave. Also, similar to the Family and Medical Leave Act, they're entitled to a continuation of health insurance. So regardless of whether you actually are subject to the FMLA, you still have to continue any group health insurance. What do you need to pay them for this leave? If they're taking leave really because of their own COVID-19 related reason, if they're subject to a government quarantine, if they're advised to self-quarantine, if they're experiencing symptoms and seeking a diagnosis, then they get their regular rate of pay in an hourly fashion up to a cap. So if you have a salaried employee, you get to break that down into specific hourly increments. They're entitled to their full pay, that regular rate of pay for every hour of leave up to a cap, $511 per day and $5,110 total for that 2-week period of emergency paid sick leave. Can you give added compensation? Could you give them up to their full pay? You sure can, but we're going to talk about tax credits in a bit, and you won't get a tax credit for anything over the cap. So that's up to you if you want to provide that, but you won't receive any tax credits. If they're taking this emergency paid leave to take care of someone else that's being quarantined or recommended to self-quarantine, or if they're taking care of the child because childcare is closed or the school is closed or they can't find care, then you only have to pay 2/3 of that regular rate up to a cap of $200 per day and $2,000 total. Same thing applies with the tax credit. So again, if it's because they're taking care of someone else or the child care provisions, then it's 2/3 of their pay. That really makes sense if you think about it, because they're not paying for other care or not incurring those other expenses for child care. How about the emergency paid family medical leave? So this is a little bit different because this actually just amends the family medical leave. There are certainly interactions between the two, but when are they going to ask for this emergency paid family medical leave? If they're unable to work or telework, which is very important, to take care of the child whose daycare has been closed, whose school has been closed, or they can't get a provider, a child care provider, for a COVID-19 related reason. Then they can request emergency family medical leave, which is actually that 12 weeks that they're entitled to under the FMLA, only this is actually paid. And please remember, this applies to you even if normally the FMLA does not apply to an employer. So FMLA generally only applies to an employer if you have 50 or more employees. Here it applies to you if you have any employees. There is the exemption if it is going to detrimentally affect the operations of your business and you have under 25 employees. Talked about that, but otherwise they're entitled to these 12 weeks of leave. The first 2 weeks can be unpaid, but they also can substitute that emergency paid sick leave that we talked about. Or if you have other policies that relate to sick leave, PTO that relates to sick leave, and it would apply to a COVID-19 related reason, then the employee can substitute your employer provided paid sick leave also for that first 2 weeks. Can't double dip, but they can substitute. Then the remainder of this leave is paid at the 2/3 regular rate up to that cap for childcare. And again, this only applies to the childcare. Also entitled to the continuation of health insurance benefits. Job restoration. If you are subject to the FMLA normally, you know that after a leave, you have to provide the employee their job back or a substantially equivalent job in your organization, barring very few reasons. Under this emergency leave, you still have to provide them their same job or a substantially equivalent job. In this circumstance, you can have an exemption. If you have less than 25 employees and the leave is for the child care provision, and this employee's position no longer exists because of the economic and operating impact that you've had on your business. So you essentially have eliminated this employee's job that was on leave. You also have to make reasonable efforts to restore them to a substantially equivalent job. So you need to look across your jobs and see if there is a substantially equivalent job. And then you have to keep looking for another year after the leave. And if something becomes available, you're going to have to put them in that position. You don't have to apply for this exemption. This is yours to own, but you absolutely need to document it if you use this exemption. And again, this only applies if you have less than 25 employees and meet that criteria. There still is a limitation to job restoration for key employees. So people that are absolutely critical, typically like C-suite employees, if they're typical to the job, to the operations of the business, and essentially your business can't operate without them, then you do not have to give them their job back. What kind of notice do the employees need to provide you under these two buckets of leave? First of all, they have to give you notice as soon as practical. So at the beginning of May, they can't tell you that, oh, hey, at the beginning of April, I was experiencing these symptoms. They have to provide you reasonable notice. Reasonable is essentially your interpretation. If you are already subject to the Family Medical Leave Act, you probably have certification requirements and certification documents. You certainly can use those for the emergency leave provision. You don't have to, but you certainly can. You don't have to go find those if you're not already subject to the FMLA. Instead, what you need to get from the employee is a signed statement with their name, when the leave is requested, the COVID-19 reason that they're asking for the leave, and a statement that they can't work or they can't telework if you have it available because of that COVID-19 related reason. Make sure you get that information in writing and retain that record. And if they are quarantined or if they're self-quarantined upon the recommendation of a healthcare provider, they have to provide you the name of the governmental entity for the paid sick leave that is requiring the quarantine, or they have to provide you the name of the healthcare provider. Make sure you ask for that also. If it's for the emergency FMLA leave, so this is for the child care provision, they need to give you the name of the child, the name of the institution that's closed, or the name of the person that is not caring for their children because of the COVID-19 related reason. They also need to give you a statement that says there is no other suitable person to take care of my child or children. Now, I realize they don't necessarily have to tell you the truth about that, and you're not going to second guess it, but you can require it. And I actually would recommend that. Keeps people honest. Intermittent leave, is it required under the emergency FMLA leave? Intermittent leave is required generally under the FMLA in certain circumstances. So is it required here? Essentially, it's up to the employer. So first of all, the employer and the employee must agree. So if they want to take a week here and a week there, or a day here and a day there, you can agree to that, but I certainly recommend that you agree to it up front. And again, you're in the driver's seat here. So where I foresee that this would happen is the child care provision, the child care leave. If in fact, if you have two parents that can share the time, you may have an employee that wants to take Tuesdays and Thursdays. If that works for you, certainly you can allow them to do that. But again, agree to it up front. If they're teleworking, you can agree to almost anything. Again, you are in the driver's seat here. If they're working on the work site, there's actually a prohibition unless you agree otherwise, specifically agree otherwise. There is a prohibition to intermittent leave if the person is actually quarantined or advised to self-quarantine, have COVID-19 symptoms, or caring for someone with COVID-19 symptoms. Again, you can agree to allow that intermittent leave, but I would be very, very, very careful about that, because the intended purpose of this general prohibition is to not infect others. And let us remember, we are in a pandemic, so if we can keep people from infecting others, that's exactly what we want to do. Your don'ts under the FFCRA are very similar to other discrimination laws. Don't discriminate against them. Don't discipline them. Don't fire them because they took emergency paid sick leave or emergency FMLA leave. Under the first bucket, the enforcement is actually under the Fair Labor Standards Act, which is significant because an employee has a private right of action under the Fair Labor Standards Act, and they can recover their wages that they were due. They can recover liquidated damages. They can recover attorney's fees, and I'm here to tell you, that ain't cheap. They can recover anything that's available under the wage and hour laws under the Fair Labor Standards Act. A little bit different under the emergency family medical leave, the enforcement is going to be under the FMLA, which means that they're entitled to their job back. They're entitled to force you to give them the leave. They're entitled to the pay that they were denied under the leave. Here, interestingly, there isn't a private right of action for that employee if you're not otherwise subject to the FMLA. So if you have less than 50 employees, even though you have to provide this leave, there is no private right of action. That isn't a ticket to go deny leave by any stretch. They can still force you to give the leave, but it does limit the private right of action. Tax credits. There are tax credits available. Consult your tax advisor. On your quarterly tax returns, your quarterly payroll taxes, you're entitled to a credit equal to the amount of paid leave provided. Remember, not if you exceed the cap, so it's up to the cap. You're actually entitled to a refund if you pay out more in leave benefits than you owe in payroll taxes, which could happen. So make sure you retain these records. There are links to all of these on the back 2 pages on resources, but make sure you retain your Form 941, Form 7200, any other filings that you make with the IRS, your employees' requests for leave and all their supporting documentation for that. Make sure you get it and you keep it, because at some point you may be asked for it. And make sure that you know how the leave was calculated. So if you have a payroll vendor, make sure you're getting with them and ensuring that they have the mechanisms to calculate this leave, particularly up to the cap, and make sure that they're showing that leave and that you're getting reports from them. If you're doing it yourself, make sure that if you need some help, make sure you reach out and ask, but make sure that you retain those records and are paying them appropriately. Some other implication under the CARES Act that has been passed that we're going to really quickly go through. I want you to know this information is out there, but it's going to require you to either get with someone else or for you to one-off these, because they don't apply to everyone. But there are some new rules or some limited temporary rules for retirement benefit plans. So if you have a retirement benefit plan like 401k, a plan does not have to, but can allow penalty-free distributions if they're COVID-19 related. So a distribution in 2020 can be made up to $100,000 from the plan without the early distribution tax. Again, plan is not required to do this, but it may. Then the repayment of that distribution can be made over 3 years, and the income can be taken for the employee over 3 years. They can choose to take it in the year incurred, but they don't have to. A plan also can amend to include increased loan amounts. So temporarily, for the next 6 months, loan amounts could increase to the greater of 100,000 or 100% of an account balance for COVID-related reasons. And again, this is only for the next 6 months. And then if a participant's loan date occurs, if their loan due date occurs in 2020, then they can get a 1-year extension of time for that repayment. Minimum distributions, a plan can suspend the required distributions for 2020. This has to be, you need to get with your plan advisor and your plan administrator to make sure that that these are some of the items that you actually want to do. any of your plan amendments, you need to get with your plan administrator now and decide what you want to do, but you have until the end of 2022 to actually make the amendments. There's also some relief for a single employer plan for required contributions. These would include any quarterly contributions. You wouldn't have to make those until the end of the year. For anyone who has an IRS Section 127 educational plan, a CARES Act provision actually allows employers now to provide up to $5,250 per year, tax-free, so pre-tax dollars, to employees who qualify under your existing Section 127 plan. That probably has limited application here, but it is available. Unemployment insurance, this helps both the employers and the employees. There are some temporary changes in Nebraska, elsewhere also, but there are some extension of unemployment benefits to individuals who didn't previously qualify. For example, if they'd exhausted their unemployment benefits, but now qualify for a COVID-19 related reason, extended to them, extended to self-employed individuals, independent contractors. The benefit amounts have increased. Through the end of July, individuals can collect up to an additional $600 per week. The waiting period has been extended and the duration of benefits has increased. So the duration is up to 39 weeks instead of previously 26 weeks. And at this point, there are some exclusions still for individuals who actually have the ability to work or are receiving other paid benefits, then they're disqualified. The CARES Act, the federal act, also extends federal financial support for states that have short-time compensation programs. Nebraska is one of those. So the driving force behind this rarely used program in Nebraska is that instead of laying off employees, can we reduce the number of hours that employees actually work? And if so, you could submit a program to the Department of Labor and tell them, okay, I'm going to reduce my employees' time by 50%. Then there is a subsidy from the Department of Labor, unemployment compensation, to make up that difference. And that's up to $440 a week. So if you're interested in that, and this is in lieu of laying off employees, then employees get subsidized for that. You can actually submit the plan to the Department of Labor, and the link is right there. Some other resources that you may be interested in, if you're interested in reading the actual law or the regulations, the employee fact sheet, the Q&A, the assistance bulletin. There are some OSHA requirements to provide a safe workplace. That's provided. Some tax credit resources, FMLA, Q&A, Department of Labor, short-term compensation site. So we've left some pretty good time for questions. So if we can, Danny, if you want to take over the screen, you sure can. And let's go to some Q&A.
Certainly here. So I can, Maggie, I can read them to you as we go. And then feel free to answer live. So the first one is, oh, and I can just answer this one. Yes, this will be sent out after. And we will have the presentation and everything available for everyone up on the generator resources page, and we can shoot that link out to attendees. And then, but the follow-up question that is, curious about furlough. What's the difference between the two, with furlough and short-term labor reduction?
That's a very good question. What is the difference? Technicality, there is no difference between a layoff and a furlough. In each situation you intend, furlough is generally used in the governmental settings. So typically what you're doing in both settings are setting a time that you believe your employees will not be working. A furlough generally is used when you know when they'll come back, but they can be used interchangeably. It's just usually furlough is used in the governmental setting.
Live, cool. And then our next one here. So is there a minimum number of employees an employer must have to qualify for the short-term compensation program in Nebraska?
There is not. Good question.
Awesome. We are just burning through these. And then honestly, the last question here is just where can I access these slides after the program? Again, we got another one in. Love it. But we will post these up on the resources page as well, or feel free if you would like just the direct slides. Again, my email is danny@generator.com. If Maggie, if you're comfortable with it, I'd be happy to share these with people.
Absolutely.
Cool. And then what was the link for info on CTC?
STC?
CTC. Coming through here. And that's probably in the in the slides as well, and I can pull that one up and happy to share that with you. But I'll keep moving through here. They're coming in here. Love it. So too many options and requirement guidelines. What would you recommend? Employees continue to work, but our industry work has decreased. Advised tax credits. And I'm putting that on Answered Live so you'd even be able to go in Q&A and read that one as well, Maggie.
Okay. In this situation, it sounds like the workload has decreased, but it's still there. You have a couple options. You certainly can lay off, like, for example, a class of employees. If you would rather not do this, do that. I certainly would recommend that you go to the Nebraska Department of Labor and look at the short-term compensation program, because you could reduce everyone's hours. So if you have employees that, for example, if you're an electrical contractor, but your work has subsided, but most of all your employees do the same thing, you could actually reduce their hours and enroll in an STC program where the state, where unemployment benefits make up the difference to the employees, and then there's a federal subsidy to our state for that. So I certainly would recommend that. As time goes on, some of the other options include termination of positions that are no longer needed. That gets a little more hairy, because depending upon how you want to reduce employees, you have some potential liability there. But first and foremost, if you're still functioning, I would definitely look at the short-term compensation program, or go ahead and lay off a class of employees. One thing to really honestly be careful of also is if you submitted for an SBA PPP loan and you're laying off workers, it could affect the amount that you receive under the PPP. So beware of that.
Awesome. Thank you so much. Going down the list here, can an employee who has been laid off with recall perform some part-time work for the employer during the layoff period?
Sure. Sure, they're not actually laid off. So as long as they're not on leave, which would be a different answer, if they're on leave, then you're looking at intermittent leave. It would depend upon what they're doing, et cetera, et cetera. Um, Essentially, you're allowing intermittent leave. But sure, if they're on layoff and it's not subject to a huge plan and you're not violating a plan and don't have a union, you just laid somebody off but periodically need them, can you bring them back? Sure, absolutely. You need an hour here and there, do it.
Perfect. Thank you so much. All right. If you have employees on unemployment due to unable to work in residential homes, when things are lifted, what if the employee chooses not to come back due to receiving the extra $600? How do you address this employee benefits?
They are entitled to their employee benefits under these new laws only if it's a COVID-19 related reason. So that $600 that they're getting extra only applies if it's a COVID-19 related reason. So they can't have their cake and eat it too.
Fantastic. All right. For short-term compensation or furlough program, is this something we need to proactively file with the government, or is it something we just apply and then send in documentation after?
You apply for it through the site, but it's not really an application that will be denied. You just have to give them your plan. It's not hard. So absolutely, if this applies to you, go in and get it done and make sure you're following the plan. It actually makes employees log their hours, etc., but it's not hard. It's certainly worth it.
Fantastic. These are rolling in. I'm loving it. All right. What if you have employees in different states, but you are headquartered in Nebraska? Can you still include all employees in the STC program or only those in Nebraska?
Oh, that is a really great question. There are other states that have the same program. I probably am going to, I can tell you that I think it applies only to Nebraska employees. I am fairly certain of that. You can include your other employees, but the supplement is only for Nebraska employees because it's pursuant to Nebraska unemployment, which only applies to Nebraska employees. But what I'm curious about is the other states. So there are a handful of other states that also have this STC program. So if you would qualify in other states, you could apply for the same program there. So I would love to answer that question, or if they want to tell me now what other state it is, I can get it answered.
Fantastic. I'll monitor that to see if it pops in.
Okay.
And then moving along. So, and for the two labor options, do employees have to wait until we get confirmation of the program, or can they start applying for unemployment now? Mostly curious about how we reduce the gap from when they are being paid to when they're on unemployment / getting processed for UI benefits.
Can you read that one again, Danny?
Of course. And I'll also click that you're answering it live, so you can read it on the answered page. But it says, and for the two labor options, do employees have to wait until we get confirmation of the program, or can they start applying for unemployment now? Mostly curious about how we reduce the gap from when they are being paid to when they're on unemployment / getting processed for UI benefits.
They can't double dip, and there is no waiting period for unemployment anymore. It's immediate. And so if they're on leave, once they go to unemployment, it's immediate. There is no waiting period anymore. If I understood the question correctly. If I did not, please ask it again.
Certainly. And then just kind of a jump back to this additional states question. The states are Missouri, Iowa, and Nebraska. He says, I believe Missouri has a 5-employee minimum. Not sure about Iowa.
Okay. I will research that and answer it after, specifically on those two states.
Awesome. Thank you so much. All right. So then Christina asks, if a business lays off employees providing no hours, but still is paying for benefits like health insurance, would this be a situation for short-term compensation, or does the business have to provide some hours or some payment to qualify for short-term compensation?
In order to qualify for the short-term compensation, yes, there needs to be, it can only be a reduction in hours between 10 and 60% of employees. And then there's a subsidy for the remainder of the time from the government. So it has to be just a reduction of hours.
Mhm. Cool. All right. As a Nebraska employer, I have an employee in Iowa, one in Nebraska, and one in Missouri. How do I make the STC program work, or can I? And this might go right back into what you answered before.
It certainly does. So your unemployment taxes are paid through the specific state. So I'll look at Missouri and Iowa and let you know. Certainly applies to your Nebraska employees, but the relief could be sought from Missouri or Iowa, depending upon what I find out.
So it looks like we have a few more questions here. So can you hire new employees if a worker refuses to come back and you apply for a PPP?
Yeah, so if I understand the question correctly, you have an employee that found out they want to stay at home permanently. Can you actually hire another employee to replace them? Yeah, you can. Certainly you can. Be careful in scenarios where you're hiring, but then you're saying in that other employees aren't necessary. Make sure you can differentiate that. So if you're actually terminating an employee, but hiring for a different position, make sure you can differentiate.
Awesome. Cool. Looks like we have just two left here. Where do we submit docs for furlough? Is there a link, or do we need to talk to a lawyer? Not able to find it on Google.
Okay. If you're actually going to lay off employees, that's your decision. You get to decide how, you get to decide when, you get to decide for how long. Just do a great job of communicating with your employees. Do you need to talk to a lawyer? No. Honestly, you don't need to talk to a lawyer. The problem with layoffs that I've seen is if you're not laying off all employees, you're just laying off some. You need to be careful so you're not running afoul of any discrimination laws. And then actually, as you bring them back, making sure you're abiding by discrimination laws. But otherwise, for a furlough or a layoff, it's entirely up to you.
Awesome. Cool. Thank you, Maggie. And then last question we have here. Can we call it's more to you. Can we call Maggie direct for suggestions in our scenario? I want to do it right for our 2 employee and 2 owners, which are W-2. I guess.
Absolutely. Without a doubt. Please call me. We're all in this together.
Certainly. Well, cool. And that looks like all the questions that were shot in here. Just a reminder to everyone, if something pops up and you wanted to get in touch with Maggie for additional questions, again, reach out to me at danny@generator.com. I'm happy to pass along your information for you. And again, for those of you that want to review this presentation later, it will be available on our Generator resources page. And if you would like to chat further, we are hosting office hours all week with myself and the rest of the team to try to help you address some of these questions. So feel free to reach out anytime. Hope to see you at our additional webinars tomorrow, Thursday, and Friday. Tomorrow we have state and local resources, which with Christina Oldfather from the Lincoln Partnership Economic Development. Thursday we have mental health resources, and then Friday we have resources and strategies for nonprofits, and we also have strategies and advice for how to make the most out of this economic downturn. So feel free to share this with your colleagues in your network as well. The more the merrier. But thank you again so much for coming in today, and thank you so much to Maggie.
Thank you. You're very welcome. Thank you very much to Generator for providing this. This is awesome.
Awesome. Well, I'll close it out now, but Maggie, I will make sure to share with you the questions from the people about the specific states and everything, so we can take care of that. But thank you, everyone.
Great. Thank you.
See y'all.
Bye, everyone.